don't know me, I do family law. You might think I'm crazy for doing family law. I think it on the regular. Do I have any family law paralegals in here? Anybody here who doesn't work for me? We do family law. I've been in private practice for myself since about 2005, so about 20 years now. I've been pretty much dedicating my entire practice to family law. I used to do a little bit of criminal, and about 2015 or so, I was just going to do the family law because I felt I was having a little bit of an issue, like with moral authority. If I'm doing certain criminal cases and I'm telling you to behave better, you know, like, because that's really part of our job as family law attorneys, is to try to find people's better spirits, their better nature, hopefully, and maybe, you know, get them to make the right conclusions with our decision, or with their decisions and our guidance. So we have an office in Panama City, we have one in Fort Walton, we have one in Pensacola, we have a satellite office in Orlando. We have some remote attorneys working for us in Indian River and West Palm, so we do family law all through the state. I tell a lot of my consultations, if you tell me something that I haven't heard, I'll give you a better deal, because this is Jerry Springer of law. And that usually breaks the ice. It also helps me get the truth about really what happened, what's transpired. So today I was asked to speak to you guys about communications. I must admit, I really wanted to talk about AI, and I got told no. So I got communications. When I told my wife that I got communications, she looked and wanted to know if the person was crazy. I don't know what that says about our marriage or our communications, but you can see her face now. She'll tell you the truth about how good of a communicator I am, but it's a little cumbersome. We'll start off here, you know, talking about some of the issues that I really wanted to touch on. We're going to try to understand, you know, the communications process, understand the ethics behind it, your boundaries as paralegals, how you can maybe keep within the boundaries and stay in your lane and still be compassionate and good communicators. You know, as somebody who's been doing this for 20 years in family law especially, if you've ever had, has anybody had just a little bit of time to spend family law before they decide they want to go do something else? Okay.
23 years.
We go to this conference with other attorneys all the time, and they're like, "Oh, I did family law for a week." So, but for those of you who are there for the week or the month, or you know, you'll know what I'm talking about. Family law really tests out your ability to communicate, you know, to stay in your own lane and not to overstep the bounds, because it is so emotional. And I think that's, you know, maybe will make me a good presenter for you guys. In addition to that, I think with family law, you know, you always have, there's sympathy. You know, you feel bad, like someone's kid's missing, like he took the kid, and I don't know where the kid's at, and I went to the bus stop, and he said he asked the kid, you know, and you want to help them, and sometimes that wanting to help makes you want to creep toward edging over the line of the communication, or it causes you to get flustered because you're not expecting that type of a phone call, because it may be, I'm scared, or I'm hurt, or this has just happened, and I'm in a domestic violence situation. So, you know, with that being said, we're going to try to explore those. We're going to try to go through some objectives and do these learning objectives, hopefully make you better communicators while staying in your lane. In addition to that, I've been joking that I'm also the heavy, because half the speech is if you do this or you don't do that, you committed a third-degree felony, which is not what I go to the, you know, CLEs, and I don't like, you have to keep saying I'm gonna lose my bar license. But you know, so that's where we're at. So that's gonna be some part of it. Let's see if this works.
Look on the back and see if it's on.
Connect. Oh, is it on? There we go. So I wanted to start off for just a minute talking about Miss Sharon. I like to joke around a lot and then say that I spent $100,000 on a law degree, but it was Miss Sharon who taught me how to actually practice law. She was a paralegal I worked with. I started my career with her as a law clerk, and she worked with me until her passing. she really taught me a whole lot about how to treat people, how to have ethical communications, how to be there for them, and how to, stay within your lane and stay professional while doing that. And so, she was my teacher, so I thought it would be appropriate to share that with you guys today, because some of the lessons I'm gonna share with you, she shared them with me. So, in furtherance of her spirit, that's what this presentation is about. So, the first thing, about communications, and why they matter is, everybody's here to be a paralegal, and I'm sure you're passionate, and most of you are like the Aaron Brockoviches of the world, but it's a business, right? Practicing law, unfortunately, is a business, and we're in an environment with people we have to work with. So, effective communications makes everybody more efficient, which makes the law firm more productive, hopefully more profitable. Smooth communications create better work-life balance. If clarity is kindness, is what someone told me, knowing what's expected of me and when the deadline is, what the client's needs are, what their expectations are, that can really, reduce a lot of the stress, hopefully. Stress on you, stress on the client, stress on the lawyer you're helping and assisting. So, that's why it's important. Obviously, you can save a lot of time. There can be a whole lot less confusion if everybody's a good communicator, okay? I've had plenty of paralegals who worked with me over the years who've said, if you just tell me what you want, and I'm like, I thought I did tell you what I want, but there was a breakdown in communication. And the paralegal's probably right, because Danny will point out, I will say about 3 words and think that it was very clear, and then he'll come back and say, did you really mean? And it'll be about 3 paragraphs. So obviously less confusion, saves time, makes people more efficient, and makes a better practice. Something we've really been working on in our practice is better communications with the client, because it builds trust. Especially in family law, you have a lot of people who are going through a very emotional time. Anybody here do insurance defense work? Okay. Anybody here represent people who you would say that are professional litigants, like the insurance companies always exist to get sued?
Yeah.
They know what's going on, they know what a motion for summary judgment is, they know exactly how much they're gonna spend on the case before they actually get into it, and what the school point is for settlement. In our practice for family law, a lot of times this is the person's first interaction with the court system at all. So if we could communicate with them better, and we've done stuff like use a program called Case Status to give them the stages, to put information and checklists about what happens in each stage. We've been working on adding videos to the stages for people who maybe not readers and want to watch, or maybe more auditory visual. It builds trust. If you build trust, hopefully that means less phone calls, less stress, less bar complaints, less negativity. So that's a good reason to care about communication. And this is a reality check I was going to share with you guys that I saw that I thought was pretty interesting. Law firms with above average productivity spend 12% more on communication and practice management, and they earn 21% more in profitability. So it's over 100% return. Easy. Just on having good communications, good management of those communications, of the documents, and everything that are coming in and out. And of course, as an owner of a law firm, profitability makes me happy, should make the paralegal happy, because it's how I pay the paralegals and give them bonuses and perks and things like that. So it pays to have good communications. All right. Critical fact number 1. If you take nothing else from today, I want you to remember this. Because your job as a paralegal in a ways is to protect your lawyer, right? Help your lawyer. Breakdown in communication is the number 1 reason clients file bar complaints against lawyers. Poor communications destroy the trust with the attorney and the client. Right? So, oh, but they called 5 times today. Call them back. Oh, they're always emailing. Respond. Cannot stress enough letting the communications go, and how that will always lead to a bar complaint. It never fails. It will lead to problems. Obviously, your attorney won't be happy if they're getting a bar complaint and there's been some breakdown in the communication. I tell our paralegals, and they may not like me for it, even if it's, I see that you've asked this question, I'm waiting on Mr. Virga, it may not be till Monday. At least there's a response. in the record. We use Clio Portal. I'll kind of talk about that here or there. Our rule is 24 to 48 hours. There has to be a response in the portal. The paralegal, the attorney are on the portal. Our business manager's on the portal. She looks. If it's over 24 to 48, somebody's getting called into the office to know what's going on. It is the #1 way. I had one guy talking about bar complaints. I'm gonna bar complaint you because y'all don't ever talk to me unless you want damn money. And I'm like, what? So I go to Clio, which I like because it logs everything. I'm like, what did the message December 10th say that we sent you? What about the one on the 15th? What about, I was like, I know, I can tell you didn't even open them. It shows me. I was like, we've communicated with you every 2 weeks. We also have in our firm, case management day that we assign to all the attorneys. I don't know if anybody else has case management time allotted on the calendar. At the end of the case management, we do like A through M 1 week, we do N through Z the next. When it's the A through N week, I expect the message to go out to every client with an update. And we track that and put that into the system, so that even if you don't call, you're not the squeaky wheel, you're the good client sitting off to the side, you know, waiting their turn for their court date or their next step in the process, that you don't get forgotten about. And even a no update is still communication. Hey, we're still waiting, mediation's 2 weeks, got any questions, let us know, but you've communicated, all right? So that's the #1 reason people get a bar complaint. I'm not saying anybody's getting disbarred for lack of communication, it can happen, but, you know, keep that in mind. And I think this is becoming more and more challenging because we have text on your phone, we have text via Clio in our office, we have a portal, we have Clio co-counsel type messaging that we try not to use. We have email, we have stuff that comes in the mail, we have clients that drop off notes at the door. The number of ways that people communicate now and how they want to be communicated to, I miss the days of just, if you really cared enough to communicate with me, write it out, go to the post office, back then pay 58 cents or whatever it was, and mail it to me, and I'll get it in 2 days, and I'll get it back in response in 3, and 13 days you'll have your answer. But and people are really now wanting instant communications because of the world we live in, and that makes it more and more hard on us, and pressure on us. In fact, the bar I know was doing a feasibility study of why so many lawyers to practice the law and then go do something else with their law degree. And one of the people in the family law section asked me about it, and I said, it's because it's the Florida bar. And what do you mean? I was like, well, you got these expectations that I have to respond within this time, I have to this, you know. I said, with today's world and the pace of how fast these things are going, to communicate in a timely manner with all these different ways of the communications are coming in, it causes a lot of stress. And you know, nobody wants to miss one. I don't think that very few people who just want to ignore the person or ignore their client, but you know, maybe you can miss something, or you know, maybe there's too many avenues, too much noise coming in all at once. So, but do keep that in mind in your practice. Run into the fire, put the fire out, talk to the client, you know, rather than let it build into an inferno and then it burns everything down. All right. So paralegals, I am convinced that you guys are the most important people on the planet, all right, as far as lawyers are concerned. Next to my wife, my paralegal is my right hand. Okay, I don't know how to e-file, I'll tell you that, I'm not an e-filer, I've practiced law before e-filing. There's lots of things that if I didn't have a paralegal, I would be screwed, okay? So the paralegal, in my opinion, is the hub of the law firm, law office, okay? And they're also the person who receives and distributes information throughout the firm and to the clients, okay? So as this hub and the hub of communications, you know, you're responsible for making sure all trains run on the same time. You're getting information from the court, you gotta calendar it. You gotta tell the attorney, hey, the judge entered a deadline. You're getting phone calls, you're getting questions asked to you. I can't answer that question because I don't wanna practice law, I wanna be a paralegal. I need you to call this person back or address this. You know, all information generally is coming through the paralegal. And so as that hub, that conduit, you know, I can't explain how important, you know, y'all's ability to communicate is and what an important role you play. I sincerely, you know, believe, like I said, there's not many lawyers out there who can truly practice and pull it off, especially with any volume of cases, without a really kick-butt paralegal behind them. When you master this role too, everybody likes job security. I like job security. I have 3 kids. When you master this role, you become indispensable because you make sure, like I said, the trains run all the time. Nothing's worse than when a paralegal tells me, hey, I'm moving on, or hey, I'm gonna retire, because I know all that information and all that knowledge that person has is gonna go with them. So you become indispensable. So to me, that's a great way to have job security as a paralegal, is make yourself indispensable, make yourself that hub, control the communications, be on top of it, tell your lawyer what's being said, what's going on. Some paralegals have said, oh, I'm babysitting. To some degree, you probably are. I'm not gonna lie. Paralegals are sometimes more on top of it than attorneys by far. Okay? So these are kind of our objectives that we're gonna go through. By the end of this presentation, hopefully we're gonna be able to identify the boundaries of permissible communications for paralegals under Florida Bar Rule 4-5.3 in Chapter 454 of the Florida Statutes. Differentiate between information and legal advice when communicating with clients about documents such as parenting plans and court orders. Apply the Florida Bar UPL Advisory Opinions to avoid unauthorized practice. Implement ethical and professional use of digital client communication platforms while maintaining confidentiality per Florida Bar Rule 4-1.6. Recognize legal obligations under Florida Statute 39.201 and 741.30 when responding to disclosures of domestic violence, child abuse, or threats of self-harm. Understand and apply Florida mandatory reporting requirements, documentation protocols, some recent legislative updates and things that are coming down the pipe. So let's talk about 4-5.23. Does anybody know what 4-5.3 and 4.54 are? It's okay if you don't. I'll be honest with you, I had to look them up too. I knew what it, once I saw it, I knew exactly what it meant, but it's not something we think about in those terms on the daily because we know how to do our jobs, but it's one of those things that we have to probably revisit and refresh and rethink about. So, all right, for our first learning objective, we're going to establish the foundations and framework for all your client communications. Rule 4-5.3, okay, has some pending 2024 proposed amendments that address AI supervision. Okay, both the core principles remain the same. So all paralegal work, including client communications, must occur under the attorney's supervision. Currently, there are 4,661 registered paralegals practicing in Florida, and we're seeing 12 to 14 attorneys disciplined monthly for the unlicensed practice of law. Okay. I wanted to mention the proposed amendments regarding the AI. Okay, not that I'm not making an AI presentation like I wanted to, but I want you guys to know that now the attorney is going to be supervising you, and you might be using the AI, and now I'm supervising the AI. So it's the brave new world we live in. Real quick, has anybody used AI to enhance their communications? No. Okay. So you might know how AI might enhance your communications. For those of you that don't have to do it with a case. You write your letter or whatever your note is, your communication. You put it into Chat GPT or Claude or any of these platforms. Make it sound friendlier. Make it use less legalese. Make me sound kinder. You may think that this is funny. Has anybody heard of My Family Wizard? All right. My Family Wizard is a communication portal for parents going through a divorce. Hey, the kid's got a baseball game. What time? Who's taking it? The back and the forth go through there. I recently spoke to a spokesperson for My Family Wizard, They now have AI built in for tone moderator. It goes into the red if you start to sound like a church, or you're being accusatory, or, you know, to help people with communications. Now, I'll be honest with you, I do use AI. I do use AI, especially when I write letters. I can usually write 4 or 5 sentences and get a page letter that makes me sound a lot more friendly. Because, you know, my communication would be hearings on Tuesday, you know, pre-hearing meetings, you know, Friday, see you there, you know, and it'll turn it into, you know, a much more spelled out, kind, you know, letter, professional letter. So I just want you to know that those are all things that, you know, now the lawyer, the person who's ultimately responsible, is now supervising. Okay. So I thought that was kind of neat, you know, and I do think that you're gonna see a lot more, like even in our Clio platform. Does somebody use Clio? All right, I'm not getting paid by Clio, but even when we in the portal now, we go to Clio, we go to respond, it suggests a response. The AI is trying to suggest a response for us. If you write a response, you can ask it to enhance the response. It'll try to clean it up, spell check it, whatever, you know, make it sound friendly, whatever. It's gonna be built into every probably form of communication in the next few years. Okay, so, you know, don't let, if you're using it, I would suggest you talk to the attorney about how you use it. You know, I would prefer as an attorney, if you've used it, to tell me that you used it before we send it out. In fact, if I use anything, I'm working with somebody, another attorney, whenever I've used AI for anything, I automatically watermark it AI assisted. You know, so that we can, you know, make sure that we double check it. But it is great because it can type 3,000 words a minute. I cannot type 3,000 words a minute. So it's you know, something that's coming down the pipe for sure. And it's gonna change the way we do things. You might know what chapter 454 is.
Is it unlicensed practice of law?
Makes unauthorized practice of law a third-degree felony. Your communications must stay within the clear boundaries that are established. You can schedule, you can gather facts, you can explain procedures, and you can transmit attorney decisions, but you cannot interpret consequences or provide legal advice. And that's a fine line. It really is, because I've sat there and I'm listening to the paralegal, I'm like, oh, man, I don't know. I mean, you know, because you want to help people, but you always have to be cognizant of where your position ends and where the paralegal, or where the lawyer's begins, you know, so please be careful. You know, I have a friend, he's a criminal defense attorney. He often says that, was it the path to hell is paved with good intentions? I just wanted to help him out. I knew he was in trial. I gave him the information. You know, you don't want that to happen, all right? So again, scheduling appointments, court dates, gathering factual information, explaining procedural steps, transmitting attorney decisions and instructions, and, you know, try not to get tempted to help, all right? I know that sounds bad, but you can hurt yourself by trying to help somebody else, all right? We're gonna move on to learning objective number 2. You know, this is where paralegals most commonly stumble. I think the distinction between legal information and legal advice, you know, is crucial. Legal information involves facilitating access to documents and directing clients to resources. It's about showing rather than interpreting. Legal advice involves explaining what documents mean, interpreting legal requirements, or making recommendations, you know, is where we can't go. Notice the difference in some of these. I can read to you what the parenting plan document says about exchange times. I can direct you to chapter 61 of the Florida Statute for Child Support. I can show you where the motion filing deadline is stated in the court papers. I can provide you with the court's financial affidavit form. Here are some prohibitives. The parenting plan means you'll get more time with your children. You should ask for more alimony based on this evidence. He should be paid to pity. If you file this motion, the judge will likely rule in our favor. This is a slam dunk. Your ex-spouse's behavior violates this custody order. Mr. Virga is going to put him in contempt. You know, you have to be careful. Because look, honestly, I tell people all the times, some of the paralegals I've worked with, if you had a bar card and a suit, Annie, you could probably go to court and do as good of a job as I could. You know the law. It's hard when you know the answer not to want to let it come out, because you want to help the person. But you gotta stay in your lane, you know, hey, I can read it, it's, the order says this, or, hey, you can find this here, you know, here's the family law financial affidavit, here are the interrogatory forms, or whatever, you know, that you're needing to reference, but, you know, don't give the advice, okay? Alright, so, we're gonna move to learning objective 3, and that's gonna be applying UPL advisory opinions, some current UPL enforcement, you know, and the climate for that. Just so you know, the Florida Bar maintains the largest budget, 1.8 million nationwide, for prosecuting the unauthorized practice of law. The biggest war chest to go after people.
Yeah.
You know, like as a young lawyer and as an old lawyer, the Florida Bar scares me. I don't even like to get mail from them when my dues are due. When Danny, who works our office, goes and checks the mail and we have something from the Florida Bar, I make him open it and read it to me. Okay? You don't want them in your life and they have the money to go after you. And we pay them the money to go after us every year. So, with that being said, the biggest war chest in the country, you want to make sure that you don't get on the other side of that war chest. Those things can get real bad. Alright. Like I said, I don't like being the heavy, but I'm going to be the heavy for a minute. I did do a slide on the heavy because it just depresses me. But I did, you know, bring some notes. We're going to talk about what happens when you find yourself on the other side of the line. Alright. Florida Bar versus Riccardi, 1974. It's the key case establishing paralegals court appearance is prohibited. You know, without a lawyer, you know, you can't go to court. Edward Riccardi, a paralegal, appeared in court and actively participated in pretrial conference attempting to represent a plaintiff. Violation, Riccardi told the court, according to certain rules of the bar, the person not qualified can indeed represent somebody and give advice or wish to take a fee in certain paralegal activities. How come the court permanently enjoined him from practicing law? You know, obviously nobody's going to court without their lawyer. Hopefully no one works for a lawyer who would ask you to do that, but if you don't do it if you're asked. And you know, when you communicate with the court, that's a form of communication. Make sure you're staying in your lane as the paralegal. That it's clear that you're a paralegal, that you're not the lawyer, you're not advocating necessarily like the lawyer wasn't, you're denoting who you are, okay? That's where I think we've gotten from the 70s now to probably everybody's clear on that. I will tell you, one time as a law clerk, I was sent to court, and I was very upset that my boss was telling me I had to go. And the very first words out of my mouth, and I walked into the circuit judge's chamber, I was like, you know, I'm not gonna say the guy's name, but he sent me here, and I know I'm not a lawyer, I'm pretending to be a lawyer, but he had another court case, and he didn't want somebody not to show up, and the judge, it was Gulf County, Florida. Anybody go to Gulf County before? Okay. He was eating a bowl of cornflakes with some milk dripping on his son, you're good, I know you, you're good people. You're not practicing law. And I was like, thank God. But if you do get asked to go for some reason, like, you know, my God, the attorney's on the way, I would start off with, Judge, I'm not a lawyer. I'm not pretending to be a lawyer. The attorney's had a massive car wreck, or he's on his way, or whatever, you know, whatever the crisis is. Start off with, you know, making sure you're clear on that. All right, Florida Bar versus Pascal. Paralegal overstepping their boundaries in a real estate transaction. Now, I don't do real estate. I've heard, you know, certain circumstances of, you know, paralegal might be able to do closings, but I did think this was kind of interesting. Pascal, working as a paralegal at a president of Atlantic Title Corporation, was fingered representing a client in a restaurant purchase and closing without an attorney. Violation, gave legal advice to client without attorney present. Correspondence with opposing counsel on the attorney's letterhead from that closing agency when she signed for the firm. without disclaiming her non-attorney status. And the court found she represented clients at closing without attorney supervision. Outcome, permanently enjoined from the practicing law in order to pay all court costs. Okay, so when you sign something, and we're gonna say this probably about 25 more times today, paralegal, paralegal, signature block, paralegal. Make it abundantly clear, okay? Florida Bar versus Neiman, paralegal conducting settlement negotiations. Neiman, a paralegal, participated in settlement negotiations. Violation, the court found that conducting settlement negotiations constitutes the unlicensed practice of law. Outcome, enjoined from various activities, including settlement negotiations and client contact. Significance, clearly establishes paralegals can't conduct settlement negotiation. You may think, I'm not going to mediation without the lawyer. I'm not in the world we live in, with the emails, and the speed at which we come. And be careful of what you say isn't somehow swaying the settlement negotiation, or you didn't put your toe into the negotiations, on accident. And that's my point with that one. I don't think any of you good people are gonna come down here, I'll get this thing settled, or I'll go in there and get them straight for you and get a settlement out of them. We'll go one more of these and we'll hopefully move off some of the depression here of this. Florida Bar versus Span, attorney discipline for paralegal supervision failures. Attorney Span allowed non-lawyer employees to sign letters for the firm without disclosing the non-lawyer status, and allowed legal advice to be given in letters authored by paralegals. Violation, failing to adequately supervise staff and assisting in unauthorized practice of law. Outcome, Span was disbarred. Established that paralegals may sign letters only if non-lawyer status is clearly disclosed and attorneys are responsible for the supervision. So, how many people here want to get their boss disbarred? So, consequences go up, even if you make the mistake, the attorney is still responsible. So it can flow up, even an inadvertent mistake could help hurt somebody else. So it's very, very critical. So those are just some of the basis of opinions, historic cases of where we find ourselves here today. Like I said, bottom of the line, when in doubt, just don't do it. Get the attorney, make him do his job, make her do her job. I know we're lazy. It's okay, we'll get over it. We'll get over it, and then if you have a hard time about it, just maybe pull out the Span case. And do you want to read this about how the attorney got disbarred for the paralegal doing it? And they'll probably get off their ass to do it. All right. Learning objective number 3 here. Just want to take a moment to discuss some safe communications practices and some red flag communications to avoid. Again, always identify yourself. This is Connie Brate, paralegal with the Virga Law Firm, or Mr. Melendez. Oh, Connie, it's gosh, I'm so glad I got you on the phone. I was just wondering, do you think I could get part of the passive appreciation on the house? Oh, that's a good question. Excellent question. Let me get Mr. Melendez for you. Let me get you an appointment with Mr. Melendez. When you refer something to the attorney that you can't answer because it's outside the lane, in your portal, whatever you're using, your form of communication documentation, document it and document the escalation. Why? I'm not gonna lie, some of these clients will lie. Oh, she told me no. Oh, no. Here's where it came in. Here's where I messaged Chris, or, set the appointment. Clearly said, this was above my pay grade. We can't do this one, and moved it on. And document it. Just like I said, my client, he was like, y'all never communicate with me. I thought that was the best thing I ever paid Cleo for, was to be able to go down 30 messages that he never opened or responded to, and saying, do you want me to print those out and mail them in with your bar complaint, or do you want me to go ahead and send them now? I'm so sorry. Okay. Red flag communication is to avoid, of course, explaining what legal documents mean. What does this mean? I don't know, you got sent to me, I saw it on the clerk's site. Hell, I saw it on the clerk's site before you even mailed it to me or before. I don't know if anybody else has that in family law. They have learned that they can watch the clerk's site and they know before I know that the judge has done something. What does it mean? Okay, it's a good question. Let me go ahead and get you set up with your attorney. Discussing case strategies, likelihood of success. Like, Connie, you've been with me for this. We're in the trenches. What do you think? Am I gonna win? No, don't go there. Interpreting court orders or opposing counsel's actions. Don't interpret the court order. Surely you could say paragraph 3 states or highlight, but you can't go interpreting. Making recommendations about settlement or litigation decisions. I think those cases pretty much also highlighted those. I'm a firm believer, at least for us, my rate is $400 an hour on most cases. Connie's is substantially less, Shauna's is substantially less. If I can call Shauna and get the information from Shauna, I don't have to pay the attorney for the attorney's time to explain it. And then that's why, they put the heat on you or start to cry and make you feel bad, so you wanna be cautious about that, like again, that you don't let your emotions cloud your judgment because you're trying to help somebody get in trouble, okay? Number 4, we're gonna get into some digital communications. Okay. We live in probably the most rapidly evolving digital landscape of forever. It's never probably gone this fast, things have never changed this fast, and it's constantly evolving. You can't discuss communications in the modern era without discussing computer technology, AI, portals, internet, Zoom, all these things that, and like, I don't think I'm that old of a lawyer. I've been doing it for 20 years, but I think that the guys before me practiced their first 20 years without any of these changes. And these are just changes I've seen. Hell, I think we barely had internet when I started. If my boss paid the bill for it, we had it. That was about it. You had some Westlaw, but now it's really changed. I remember one time about somebody early on talking about service by email, and it was actually like people were laughing. Who the hell would do? You can't do service by email. That's not trustworthy. And then I looked a few years later, and I'm like, well, damn. All right, now we're doing service by email. All right, I hate service by email, by the way. So if I like technology, I don't like it in law sometimes. We always have to ensure that the technology we're using has the safeguards in place that we protect confidential information. All right, and while you're not the lawyer, you're not the person who's maybe making these decisions. Hopefully, you're at the table. When those decisions are made, and your firms are talking to you. You are floating things. That's why we kind of wanted you to know about this and be thinking about it too, because you might accidentally choose to send a communication in a method that's not really that secure. Okay, or and honestly, I have trouble with this as an attorney. I would love to really pick somebody's brain at the bar. I don't know how the hell Dropbox works. I don't know what the security protocols are. Leo tells me it's like 2-key authentication encrypted on both ends, and I don't know. I'm not but it's my ass if it goes wrong. I don't think that's necessarily fair, but it'd be great if some of these technologies were approved by the bar, and if it was approved by the bar, I'm good. I think that might be a better way of let the bar figure out if it meets their criteria or not. But always have to ensure that the communications are confidential. You gotta take reasonable measures to investigate the technology. Use the technology in a manner that safeguards the client's confidentiality and information. Since AI is a hot topic, I wanted to mention this Ethics Opinion 24-1 from January is now requiring informed client consent before using AI tools. They know that you're doing it. It's a new one coming down the pipe. I don't think there's any cases or anything on that, but it's out there. Digital communications will kind of move fast through. End-to-end encryption, secure video conferencing, client portal, regular security updates, email communications, use a professional signature block, identifying yourself as the paralegal, subject line, have protocols for the client matters. Be careful about blind copying and who's copied on the email. Don't want to send your message to opposing counsel on accident, or retention policies. Make sure you're retaining emails, documentation, logging them into your portal, Clio, Smokeball, whatever it is you're using. You're keeping those for a lot of reasons, not only for the bar, but for your own protection later on. All right, we're going to talk about 39.201. That's the mandatory reporter requirement for child abuse. Any person must report suspected child abuse immediately. Its statewide hotline is there. Failure to report, third degree felony. Well, they want to always give paralegals a third degree felony. All right, so, however, this is one of those circumstances where knowing the exceptions would be more important than the rule. Critical legal distinction, 39.204, attorney-client privilege. Attorney-client privilege is preserved under Florida statute 39.204. So, client calls the law office, I may have engaged in child abuse, or I did engage in child abuse. Oh, the law says everybody's got to report. It does not waive the attorney-client privilege. I called the bar to make sure we were right on that. To call the ethics hotline. Paralegals are protected and obligated to honor the attorney-client privilege, when working with an attorney. So, do not fall for that one. There may be some exceptions about bodily harm occurring in the future, criminal activity. Go talk to your lawyer. Maybe you and your lawyer have a chat with the folks in Tallahassee at the ethics hotline and figure it out. But don't just, I need a report, because you can get in trouble. Recognizing this, like I said, consult, direct report, talk to your lawyer, make a decision maybe after consulting the Florida bar. Learning objective 5, recognizing disclosures, obligations, and attorney-client privilege. There are 105,298 reported domestic violence accounts in Florida. 1/3 of the perpetrators violate existing protection orders in Florida. Approximately 200 annual deaths from domestic violence in Florida. So if you're doing family law, any type of law, but especially family law, this may, these are not unusual phone calls. Red flags that there could be issues. He threatened to hurt me if I file for divorce. I'm afraid he'll take the children and run. She said she'd rather die than lose custody. The bruises are from when we argued about visitation. Immediate response, stay calm, listen without interpreting, document the exact words that are used, don't paraphrase it or embellish it, immediately notify the supervising attorney. If it's a crisis, oh my God, somebody's got a gun, call 911, or I'm gonna call 911, or can I call 911? If you need to provide crisis resources, maybe while awaiting an attorney, if it's something that's pressing, and they're okay with that, or they need help. Suggest that they do it, probably even the safer way of doing it. All right, some learning objectives. We're communicating with the court all the time. 54,000 electric filings daily statewide. 1.1 million monthly submissions. 220 self-represented litigants. Had a self-represented litigant the other day. Opposing counsel emailed or e-filed, said service by e-filing. Yeah, I never was part on the e-file. Probably was a paralegal, attorney, glitch, but somebody we communicate with. We communicate with the court system. We communicate with pro se people. Number 6, documentation. Also want to touch on this for those of you guys that are doing civil procedure. It's my understanding the job new case management order kind of going into place. Mandatory initial discovery disclosures. That's going to be something you're going to have to communicate about. You have to put it in high gear. They're doing this in family law, even though we don't have a rule. All those damn divorces need to be done in 12 months, period. There's no reason that goes on longer than that. Sometimes it takes 6 months to get a parenting evaluation completed. So, enhanced case management requires proactive client updates. Again, document dates, times, participants, and all communication. Verbatim quotes for sensitive disclosure. Escalate the records with the attorney's response time, and take things up with the attorney. Again, my wife said that this is the one thing she's learned from being married to an attorney: document all the communications. All right, we're gonna do a scenario. I'll walk you through all 6 of the objectives and hopefully how they apply, and then we'll wrap it up. Scenario. At our office, it's a routine call. It probably wouldn't be a routine call in most of y'all's offices, but it's every day. Hey, Connie, I need to tell you something. My ex hit our 5-year-old daughter last weekend during his visitation. She has bruises on her arm. I took pictures, but I don't know what to do. Can you get me an emergency custody order? All right. Recognize this exceeds the paralegal's authority. Very serious, and I need to get an attorney involved immediately. Information versus advice. Provide process information, not strategic advice. Document exact words that the person used. UPL avoidance. Immediate attorney escalation required. Secure the immediate attorney consultation. Go drag them off their desk or solitaire game and make them get on the phone.
Celebration.
All right, man, we have a
Margarita?
cocktail. Is the next person gonna talk about substance abuse? UPL avoidance, don't practice law. Digital ethics, make sure that you save the documents or evidence in a secure portal. If the calls are logged or recorded, or however you do that, you take notes, secure it. Reporting recognition, potential for child abuse reporting here. Paralegal recognizes the disclosure, escalates to the attorney, determine if anything abrogates the attorney-client privilege. One thing that I find interesting, it says it waives the attorney-client privilege. So the person that committed the child abuse allegedly is not your client. However, it doesn't say anything about confidentiality. Just because something's not privileged doesn't mean it's not confidential. So it gets a little hairy. All right. Objective 6, precise recording file, case management system, the date, the time, what happened. Again, I would always rely on your attorney, getting the attorney involved, make them get involved. Suggest the ethics hotline if your attorney isn't automatically hop to that. Suggest it, hey, I got the number here for us, let's go ahead and give them a call. Protect yourself where you can. Your attorney will thank you for it later. I just want to say thanks to Mary, my wife, our amazing team, Connie, Shauna, Danny, everybody back at the office who've helped with this, and Asha for making this all possible. And if you guys have any further questions, I'm about to get pulled off, but I'm going to be here all afternoon. We also do a family law podcast, the Florida Family Law Attorney. If anybody has family law questions or anything like that, it's always a good source of information. And thank you guys for letting me have the afternoon to speak.
If you're interested in our podcast, Mary has our QR code. Lots of great information from paralegals. We have lots of
Thank you.
information.
Thank you.
Yeah, it's QR code takes you right to it.
Can I get a picture of you guys together?
Any platform, YouTube, Facebook.
Thank you.
Amazon, wherever you